So, on a big news day, arguably the most shocking news out of the Supreme Court today was not the ruling on the Affordable Care Act. It was a case that many court watchers widely anticipated would completely take the teeth out of the Fair Housing Act. That law, signed into law a week after the assassination of the Reverend Martin Luther King Jr. amidst riots and uprisings and unrest across the country, the goal of the Fair Housing Act was to try to fix decades of housing segregation in this country. Because housing is basically the linchpin of racial equality. It affects everything else: opportunities for employment, education, wealth, and health care. Now, today's ruling came on the case of the Texas Department of Housing and Community Affairs versus the Inclusive Communities Project. And the question was, in order to establish a claim of discrimination under the Fair Housing Act, do you have to show that there was biased intent, or do you just have to show a biased effect? It's a really important distinction because intent is, well, a whole lot harder to prove. Say a decision to place a lot of low-income housing in a black neighborhood. To prove that it's intentionally discriminatory, that's a much higher bar than proving simply that the impact of that decision results in racial disparities. Now, because the Roberts Court has been quite skeptical of the enduring necessity of civil rights legislation, many civil rights activists were not expecting a victory today. But in a surprising 5-4 decision, the Supreme Court affirmed a lower court ruling in which the plaintiff argued that the Texas Department of Housing had contributed to, quote, segregated housing patterns by allocating too many tax credits to housing in predominantly black inner-city areas and too few in predominantly white suburban neighborhoods. In other words, the Roberts Court ruled today that the Texas Department of Housing was guilty of housing discrimination, whether or not it was intentional. Joining me now is Sherrilyn Ifill, President and Director Counsel of the NAACP Legal Defense Fund. Sherrilyn, first of all, congratulations. I know you worked on this case. Big victory. I know you're supposed to say we were confident we were going to win because we had the better arguments, but everyone I talked to in the run-up to this was real nervous in the whole civil rights community.
Well, Chris, I always try to be honest, and I will not say to you that I was confident we were going to win. The case was really litigated by two terrific lawyers from Texas, Betsy Julian and Mike Daniel, and we supported them with amicus briefs and really trying to press people to understand the significance of this case and to really present the Supreme Court with an array of amicus briefs that would help them understand what was really at stake here. And I think we did that. We didn't think we would win, Chris, because this is the third time that the Supreme Court has decided to hear a case challenging this disparate impact standard under the Fair Housing Act. Clearly, somebody on the court, at least 4 members, were gunning for this. And so we were worried. But today was an amazing day. We were sitting in the courtroom as Justice Kennedy announced the decision, and we breathed a huge sigh of relief and hope that people will understand really what this means for us. Yeah, explain what the stakes are here. I mean, the question was, can you assess violations of the Fair Housing Act based solely on the disparate impact that a given policy might have, as opposed to reading some kind of racially biased intent, right? And they upheld that you can just look at it doesn't matter what the intent is, you look at the impact and you can find a violation. Why is that so important? Well, so it's not actually quite that simple, so I should explain it a little bit. You know, the Fair Housing Act was passed in 1968, the week that Martin Luther King was killed. Cities were burning all over the country. And responsible leaders recognized that housing segregation really had to fall, that we were turning into these two societies, one black, one white, separate and unequal, that the Kerner Commission talked about. And in fact, Justice Kennedy cited that language from the Kerner Commission in his majority opinion today. We all know the housing discrimination of the sort that Donald Sterling engaged in, right? A developer or an owner who refuses to rent their apartments to African Americans or to Mexican Americans or to people of a different national origin. That's intentional discrimination, and the Fair Housing Act allows you to bring claims looking at that. But the disparate impact standard is a different one. That allows you to look at what Justice Kennedy called today disguised animus or unconscious prejudices, policy decisions that appear neutral on their face but have a discriminatory effect. That doesn't end the inquiry just because the policy has a discriminatory effect. It opens the opportunity to then ask the developer, or in this case, the Texas Housing Authority, you know, what's the reason for this decision that you made? Why are you putting all of these low-income tax credit affordable housing units in African African American communities and none in the white community. And then they have to come forward with a business necessity, a reason for why they're doing this. And then the question is there another alternative way we can get at whatever is your legitimate interest without producing the discriminatory effect? So it actually opens up a really important and useful and helpful conversation with those making decisions about housing so that we can make better decisions that do not promote segregation, but that instead promote integration. The whole idea is to drop the wall of segregation, but also to provide for economic support for African American communities, still our, major source of economic support all over this country, not just for African Americans, is through home ownership and through housing stock in your communities. Segregation perpetuates weak African American housing stock, and that's been documented throughout the country. So now we have, again, some assurances that we can use this tool going forward. We've used this for 45 years in an unbroken line. Every federal appellate court that's looked at this has said this is the standard that you can use, and yet it's been challenged 3 times. And finally, the court today ended that set of challenges. Now it's up to us to robustly use the Fair Housing Act, especially at this time, Chris, when our country is so fractured, and to return to what I really see as the unfinished business of the Fair Housing Act and of civil rights, and that's getting at this entrenched housing segregation that so characterizes our country.
I'm so struck by this study out of Stanford that typical middle-income black family lives in a neighborhood with lower incomes than the typical low-income white family. There are huge ramifications for that. Continues to be one of the kind of defining features of how American race functions today, and a big victory at the court today to keep waging that battle. Sherrilyn Ifill, thank you so much.
Thank you, Chris.